Through. We're joined by Pranav Saita, National Leader, International Tax and Transaction Services at EY India, to talk to us about exactly that. Mr. Saita, let me start. Firstly, very good morning. What does this mean in terms of a development for you and your clients? Talk to us about that, especially with regard to existing investments in India. How large is this? And give us a perspective on what this could mean for existing clients looking at future investments. Likely you've got a pipeline of FIIs looking to invest into India. Does it change materially for them, the way in which you think of structures?
So the immediate effect would not be on future investments, because future investments in shares after 2017 are in any case subject to tax in India in terms of capital gains tax. But I think there is a second round of effects, in the sense that because of this, there is an uncertainty in regard to their past transactions of sale or exit of shares, capital gains earned, where the original investment had been made before 2017 and they have been claiming treaty exemption. There might be unanticipated tax liabilities that might come upon them, which presently they had felt that, based on the settled position of law as was perceived earlier, there was unlikely to be any. And because of that past unanticipated liability, the consequences might impact, as I said, in terms of mood, in terms of perception of India as a jurisdiction which is welcoming to foreign investments, and so on and so forth. And all the uncertainty, lack of stability or predictability of the Indian tax regime, and the knock-on effects that could have on foreign investor perception about India as an investing destination.
Pranav, what could be the impact for foreign institutional investors who are coming through similar structures in direct route into the into the Indian market? Will this be implemented for them as well? And while this is in relation to India-Mauritius tax treaty, other tax treaties like the Singapore or other treaties which economic cooperation agreements that we have with other nations, will that also be part of it?
So the way in which the judgment seems to be coming out, and we have to fully analyze it, but it seems very likely that there will be an impact on interpretation of treaties in general, with the result that not just taxpayers who are assessing or taking the advantage of the Mauritius-India treaty, but also taxpayers seeking advantage of the Singapore treaty or the Cyprus treaty or the like, will also be impacted by some of the ratios, principles, observations of the Supreme Court in this particular judgment. So it could really impact across the board, especially terms like tax residency certificate, which are currently respected based on the earlier judgments of the Supreme Court in Azadi Bachao and Vodafone. Now there can be a lot of uncertainty as regards the respect to be given to such TRCs, tax residency certificates, to grant the benefit of a treaty to a taxpayer. Also, the circulars of the government, which were hitherto felt to be and viewed to be binding and applicable, the applicability of those now might be in doubt based on the observations in the Supreme Court order, and so on. Also, hitherto, based on Azadi Bachao's earlier judgment of the Supreme Court, the feeling was whether or not an income is taxable in the hands of the taxpayer in that overseas jurisdiction, be it Mauritius, Singapore, whatever, that is not really so relevant. Even if there is no tax levied by that jurisdiction, maybe Mauritius or Singapore, on the capital gain, so long as under the treaty India grants exemption, that should be respected. But again, that principle also, it seems, is likely to be under question. So yes, it would impact probably taxpayers coming from other jurisdictions other than Mauritius, especially given the observations in this order, including the observations on general anti-avoidance rules and treaty grandfathering. So yes, it adds a lot of uncertainty in regard to such treaty assess taxpayers as well.
Right. Mr. Saita, from an equity market standpoint, like you're rightly saying, that I think it's time now that global investors perhaps would be recalibrating the treaty risk when it comes to India. The other question is whether or not they will now look at alternative investment avenues, such as perhaps Gift City.
Yes, I mean, everything will be open for consideration. I'm sure taxpayers, based on their own specific facts, will want to reassess their past transactions and liabilities. It also depends on the fallout effects of this judgment. Is it going to be aggressively pursued by tax authorities to maybe look at past exits, past capital gains earned over the last few years, even in respect of investments which were originated before 2017 March? And if that happens, there could be a much larger fallout. But one has to wait and see how exactly this particular judgment gets interpreted and implemented by the revenue authorities as well. It could impact even things like, for example, multinationals, and we've seen many of them now, who have come up with offer for sale in Indian IPOs. Indian subsidiaries of large multinationals are now looking at IPOs. We have already seen a few of them. And if those investments had been made before March 17, then they would have probably enjoyed exemption hitherto if they were coming from a good treaty. Now that becomes a subject of doubt.
Pranav, does it also mean that the sanctity of the tax residency certificate is can now be questioned by the Indian authorities, irrespective of whether you are coming through a tax jurisdiction or not?
Yes, very much. So hitherto the feel was that the tax residency certificate issued by the overseas jurisdiction must be respected. And that should be regarded as, for all practical purposes, the view that was being taken, which was more or less regarded as a settled position, was that a tax residency certificate issued by the overseas authorities must be respected by the Indian revenue authorities based on Circular 789, etc., issued by the CBDT. Now, that also is subject to a lot of doubt as to whether that interpretation is correct. Every tax authority, it seems now, may want to re-examine or examine on his own whether the overseas taxpayer is having a residence, control and management, etc., in that particular overseas jurisdiction, which he is claiming treaty benefit of. And that really can mean a lot of lack of clarity, uncertainty in the minds of taxpayers. Very true.
Mr.
Just
Saita,
to
thank you
clarify,
so much.
just to
Go
clarify,
ahead.
if there is, does any of these entities have any final recourse or appeal against this Supreme Court order, either in Supreme Court or in an international forum, because it's a tax treaty between two countries?
So very good question. I mean, we have seen previously in the Vodafone retrospective amendment things challenged under the bilateral investment treaty and so on. In the Indian context, in this particular judgment's case, of course, it depends on its own facts, but a review petition is possible indeed, though generally the feel is that it is unlikely to meet with success. So yes, there is a remedy in the form of a review petition, but it has very limited applicability. And while I wouldn't be surprised if the taxpayer here prefers to apply for a review, I would not be sure that it has a great chance of success. Of course, after that, there's also a curative petition and so on possible, but the chances of a reconsideration in principle is very unlikely.
Mr. Saita, it was a pleasure talking to you today. Thank you very much for joining us on ET Now.